So good evening to everyone. I'm Frank Bailey, and I am the president of Pioneer Legal. I think I know most of you, so thank you for coming out tonight. We are a public interest law firm. We launched I retired from the federal bankruptcy bench on June 1st, and we launched on June 2nd, and I still owe my wife a vacation. So we're going to get to that soon, I hope. Our focus is on education, cases, on economic opportunity, economic equality, and if you get our in brief newsletter, you'll see all of the things that we're up to, and we're already very busy. So we're delighted to be co-sponsoring this event tonight with the Federal Bar Association, Massachusetts chapter, as well as the National FBA Federal Litigation Group. And we are also co-sponsoring with the Social Law Library. And I want to make a personal thanks to Michael Saporito. I don't know if Michael's listening somewhere. I don't think Michael's been in since 2020, March 2020, but you might know Michael because he runs all of the CLE at the Social Law Library, and he taught me a lot about how to get this done. So speaking of the Federal Bar Association, I'd like to invite Joshua Siegel, who is the president of the local chapter of the FBA, to say a couple of words. And he's either going to stand on my shoulder, or I'm going to hand him. Wait a minute. Is this on? That one's not. Okay. All right, here we go.
Thank you, Judge Bailey, and good evening, everyone. As introduced, my name is Josh Siegel. I am an attorney here in town. I'm a lawyer at Lawson & Whiteson. My practice is general civil litigation, some small business advising, but I'm here tonight not in that role, but as the president of the Massachusetts chapter of the Federal Bar Association, and really wanted to just say a couple of words about the Bar Association itself. And so thank you for indulging me on that. It really is a special bar association. It's a little different than a lot of the other ones that I'm a member of, and is, I would say, the bar association for practitioners in the federal courts. The FBA is dedicated to promoting the welfare, interests, education, and professional development of attorneys involved in federal law. We have nearly 20,000 members nationwide. It includes 1,500 federal judges. And we serve as the catalyst for communication between the bar and the federal bench, as well as federal practitioners in the private and public sectors. The FBA also really is the only organization that acts on behalf of, or lobbies on behalf of, and advocates for the federal judiciary. Recently, in fact, Congress passed the Daniel Anderl Judicial Security and Privacy Act, which was a necessary step to increase security and safety for federal judges and their families. The FBA was instrumental in lobbying for that to get done for a number of years. There are tons of benefits of membership, including more programs like this one. Our chapter regularly hosts what we call Breakfast with the Bench. They're a 60-minute roundtable discussion over pastry and coffee with a federal judge, usually at the Moakley Courthouse. We have 3 coming up in the next few months. March 17th with Judge Burroughs. We have one with the First Circuit Judge Helpe on April 4th. You can attend in person, you can attend in Zoom. There are national, there are chapter-based events, there are sections and divisions on a variety of areas of federal practice. Also, I know there are a few law students in the room. Law student membership is even free. So you really have no excuse to not join. It carries into your first year of practice too. So I would just like to welcome everyone, encourage you, if you're online right now, fedbar.org. For everyone else, when you get home, it's fine. And if you practice in federal court, please consider joining our bar association. It really is a wonderful experience. So thank you to Judge Bailey, Pioneer Legal, Social Law Library for asking us to co-sponsor tonight's event. I'm looking forward to it and hope to get to chat with some of you afterwards. Thank you.
Thanks so much. So it's about time to get launched here, and we have, of course, tonight Professors Gary Lawson and Jessica Silby of the Boston University School of Law, both con law experts here to talk to us tonight about some of the major cases that are pending at the U.S. Supreme Court. Their bios are on the slides, they're on the CLE materials, but a couple of highlights that I will make. First, I know from my friend Ken Leonetti, who I know is here at Foley Hoag, that Professor Silby started out as a bankruptcy lawyer, and therefore we know she's brilliant. And maybe she'll come back someday. And I want to make a plug for her book, recently released in 2022, Against Progress, Intellectual Property and Fundamental Fairness on the Internet. I own the book. I read the book. I forgot to bring it for her to sign, but I'm going to go up to ComAv someday and have her sign it. Then there's Professor Lawson, who is I'm told, a founder of the Federalist Society, and he clerked twice for Justice Scalia. You can ask him how anyone can clerk twice for Justice Scalia during the reception later. Most important, though, and I'm absolutely serious about this, I have spoken to some law students who know them both, and they are revered by their students, and we all know that not all professors are, so good reviews. So thank you for doing it. So just a word on questions. If you're attending online, and we should have about 75 people attending online, there is a chat, and you can put in a question anytime during the presentation, and John Liberté, who is a staff attorney with us, will monitor those questions, and we will ask him to ask one question from you. If you have a question and you're here in the room, and I encourage you to do it, you're sitting on, or you have picked up a pen and a little piece of paper, and if you write out a question and hold it up, the other Pioneer Legal staff attorney is Selena Fitonides, and Selena will come by and pick it up, and we'll ask that question. I think that's all I need to say by way of introduction and rules. Okay, so let's get started, and I'm going to turn first, and the professors have given me the order in which they would like to. There we go. I should have been doing this before, but now we're catching up. Where's Mary when I need her? We do have educational materials that are on our website. If you need CLE, talk to me, but the materials are there and available, and they're really pretty good. I wrote them. So the first case is Tyler versus Hennepin County, Minnesota, a really interesting case. Who wants to launch?
Yeah. So can I just describe the way we organized ourselves?
Sure.
First? You're going to give us time?
Yes.
Okay. So
right here. John will show.
Okay. Time. Okay. So just so everyone knows, Gary had a lot, and I had a lot of fun figuring this out. So one of us is going to set up the case, put the facts together, and do the question presented, and then pretty much at random, we decided who's arguing what side. Yeah. And that's largely because these are hard cases. There are plausible and at least plausible, if not strong, arguments on both sides. And so we're going to present the arguments on both sides, and then we'll ask you to ask us questions about the robustness of them or the ambiguities or whatever. So we're gonna make the arguments. We're not actually going to debate. We're going to lay out the arguments, and hopefully leave about 4 minutes at the end of each case for questions. All right?
Very good.
Hennepin.
That's the plan. In feudal England, all land was held of the king. In 21st century United States, all private land is held of the state, more precisely of the county. Meaning, if you don't pay the property tax assessment, mean people are going to come, they're going to grab the land, put it up for a judicial auction, and use the proceeds to pay off your debt. No more land. The precise procedures differ from state to state, times for redemption, forms of notice, but the basic facts are uniform. Well, what happens if you are a 90-plus-year-old who has a condo, you don't pay the property tax on the condo, and by the time the years for redemption tick off, interest, costs, and fees total up to about a $15,000 debt. The county comes, it grabs your condo and sells it for 40 grand. What happens to the $25,000 that's left over? In about 3/4 of the states, there's a mechanism whereby you, the former property owner, can get your hands on the $25,000. In about 1/4 of the states, including Minnesota, the $25,000 is gone. Minnesota, under a statute enacted almost a century ago, says that once they grab your property and once all of the various time periods for you to redeem it have ticked off, they simply have absolute title to the property. So when they sell it for $40,000, it's not yours anymore. All of your claims have expired. That's exactly what happened to Geraldine Tyler, and she has brought a class action suit on behalf of similarly situated Minnesotans, claiming that by taking the $25,000 in excess of what she owed, the state of Minnesota has taken her property for public use without just compensation. So the text that she's relying on, the text of the Fifth Amendment, nor shall private property be taken for public use without just compensation. She also has an argument that it's an excessive fine. We're not going to get into that one here today. Well, okay, why isn't she obviously right? Well, the more basic question is, why isn't she obviously wrong? It's something of a puzzle why the Supreme Court took this case at all, because for more than half a century, the Supreme Court has been saying, look, read the federal Constitution. You got this word property that shows up in the Takings Clause. It also shows up in the Due Process of Law clauses in the 5th and 14th Amendments. Life, liberty, or property without due process of law. Well, how do we figure out whether something is property? For more than half a century, the Supreme Court has said the federal Constitution isn't the restatement of property. It doesn't contain a civil code of what counts as property. It's there to protect things that count as property, but what actually property is a function of state law. It comes from someplace outside the Constitution. Well, if that's true, Minnesota's got an easy win here. And that is exactly what the federal district court that heard this case and the 8th Circuit Court of Appeals said. This is an easy case. Why? Well, Minnesota's got a statute that says, guess what? After there's been a tax, you failed to pay the taxes before there's a tax sale, Minnesota owns the property, not yours anymore. Before that statute, it was a pretty good argument that the common law of Minnesota recognized the property owner's continuing equity interest in the property, so that even if it was sold, it would just be sold with a lien, right? But the remaining equity. But as of this statute, Minnesota has said, no, we're doing it differently. Why isn't that just end the matter? Well, 4 justices obviously think that this is something worth thinking about. And here's why Geraldine Tyler just might pull this one off. It is true that for half a century plus, the Supreme Court's been saying that property is a function of state law, and there's a lot of contexts where that's obviously true, right? The precise details of whether or not, say, there's a surface interest in land, that sort of thing. It would be very strange to think that the United States Constitution somehow picks out one uniform answer to that and the various questions in property law doctrine. But let's back up a little. Forget the takings clause that this case is all about. Let's go back to those due process of law clauses. Life, liberty, or property without due process of law. Does state law determine what counts as liberty? Well, under existing doctrine, to some extent it does. They can make things liberty interests that otherwise wouldn't be, but there's a core of stuff that Doctrine says that's just liberty. It doesn't matter whether the state says it is or not. If they're going to throw you in prison, they're depriving you of liberty, even if they pass a statute that say, you know, our prisons are just wonderful vacation spots and nobody's deprived of anything. People ought to love being in our prison. Even if they say that, no, of course, for constitutional purposes, they're depriving you of liberty. And never mind the extent to which states get to define what is and isn't life. That's a whole other kettle of fish. What about property? Doesn't there have to be necessity, a core of things that just are property regardless of what any state legislature, state court, state constitution says about it? And we do have some modest precedent in support of that. There are a couple of cases where when funds are placed in escrow waiting to be paid to creditors, they earn interest. A couple of times, states have tried to say, oh, by the way, that interest that's being earned on those escrow funds, that belongs to the state. And on 2 occasions in the last 4 decades, the Supreme Court has said, well, no, they can't do that. I mean, the interest is part of the principal. If the people own the principal, they're going to own the interest. The state can't just pass a statute saying, oh, by the way, that money in your bank account, that's now ours. We haven't taken anything. We've just redefined what property is. And that's the essence of Geraldine Tyler's claim, is that this is just like the state taking stuff in your bank account and trying to define it as theirs. And surely they can't do that. And again, when you frame it that starkly, she obviously has a point. The problem doctrinally, and here's where I'm going to stop and turn it over to Jessica in just a moment. The problem is, okay, suppose there are some things that just by the nature of reality have to be considered property. There's a whole lot of stuff in modern law that's pushing against that very hard. Some stuff that happened, let's say 1932 or so, where the Supreme Court said, well, law is really the law of states. In the 18th century, people would have talked about something called general law. We don't talk about general law anymore. Are we really talking, is Geraldine Tyler really asking us to return to that old 18th century notion of general law? There are some things that just stand above or precede the positive law of any jurisdiction? Well, the answer may very well be yes, but to accept that flies in the face of a whole lot of things that modern law has thrown out there. The other problem is, okay, let's suppose there are some things that just are property. Is the equity in land following a tax sale where the proceeds exceed the amount of the lien, is that the sort of thing that just is property? Well, every libertarian instinct in me says, well, of course that has to be. But this is not about libertarian instincts. This is about old-fangled doctrine. And that's the case that the Supreme Court's got. And oddly enough, in the entire history of the Supreme Court, they have never come flat out and said, there are some things that just are property. Right? They haven't done that yet. And it'll be very interesting to see whether this is the time when the Supreme Court wants to take on that rather large question.
So you've made my argument for me.
I just
want to say,
so sorry.
He has no notes. I've got like pages and pages of notes. He's doing this all from his head. So is there a Platonic idea of property? No, there is not. Just like there's no Platonic idea of liberty, or life, liberty, or property. Life, either, I would say. I think we could question what life is as well. See chat GPT-3. So if property, when we define these terms, or when the court defines these terms constitutionally, they always look to deeply rooted history, the patterns and the practices throughout the nation and through history, and they look at state law. They look at what have states been doing, how have they been defining these things. And the states are actually all over the map about the surplus value of a property, and whether the forfeiture of a property actually escheats the property to the state, and then the state then can take it where there's actually, that owns it, because that's a forfeiture. Land forfeiture laws are ubiquitous. They're as old as the state laws pre-Constitution. And we have had a very, very long history of forfeiture after not being able to pay your taxes, where you don't own it anymore. The ownership interest has diffused to the state. And after, by the way, there's been procedure. So there's been a procedure. She had 3 years by which to try to get her property back. She had notice. So all of this had extreme amount of process, and that process differs from state to state as well. And so once that process is expired and the property has been forfeited, the property transfers to the state, and the whole value of it, all of it. And that is historically the way all of these statutes have been used. And it is the idea that government is taking more than it is owed is an argument about the value pre-forfeiture, not what happens afterwards. Could the state pass a law and change the way we evaluate what was owed and turn it into property? Yes, they could, because that's a creature of state law. But that is not what happened here. And the court has historically, as you said, always defined property in terms of the historic ways that states have done them over time. So
we're up to the questions.
Yeah, 2 questions.
Now, let's see how that goes. First, John, anything from the online?
1 or 2. One question is, if the court invalidates the Minnesota statute, would it have any application to the Massachusetts Chapter 60 lien foreclosure statute that's in existence?
Did everybody hear that? The question is, we have a similar statute in Massachusetts called Chapter 60. So, if the Commonwealth, if a municipality takes your property for failure to pay taxes, the excess proceeds go to that municipality and not to you. And so the question is, what impact would this have on a Massachusetts statute?
Yeah, well, I mean, you want to give the lawyer's answer, or should we do it in unison? Depends
on
on
what
what
the
the court
court says. Right. So it will depend on whether this becomes a question of procedure. Did they follow the right procedure?
I
Or
see.
whether the statute, whether they're just interpreting the particular Minnesota statute and this is a Massachusetts statute is distinguishable. I mean, it depends. I don't have a good answer.
Okay, fair
No, I think
enough.
that's right. I think that's
All right,
exactly right.
and Selena?
Okay, this is a question from the audience. Under Supreme Court precedent, a taking does not equal compensation for all value lost. For example, eminent domain. So in this case, can the homeowner no longer owe the 15?
Yeah.
Own
the 15,000? So under established precedent, isn't that okay?
Well, the 15,000, absolutely. Nobody, including the homeowners here, are questioning that the state properly grabbed the property, sold it off, took the $15,000 in accumulated back taxes, interest, fees, costs that she owes. Nobody's arguing about that. Her argument is what happens to the $25,000 in value. Now, one quirk of Minnesota law, I don't know whether this is actually going to affect the Supreme Court's decision, is once Minnesota takes title, that wipes out, that the property is the sole ground on which Minnesota can pay off the debt. If there's a collapse in the housing market and they sell the condo for $5,000 and Minnesota's out 10, they don't go and try to collect the extra 10 from the homeowner. States differ on that as well, whether or not they can go after your personal property and other assets for any deficiencies. Minnesota doesn't do that. So no one's arguing about the $15,000.
Right.
Everybody 100% agrees Minnesota can.
All right, so we're going to move on to the next case, but I will say this Tyler case is one on which Pioneer Legal had retained, is that the right word, pro bono counsel, Morgan Lewis, and filed a brief in support, seeking to have the court take cert on this case, and the court did take cert on this case. And now we are in the process of preparing a brief to file on the main case because this is an issue of great interest to Pioneer Legal. So let's move on to.
Taking what position?
I mean, the briefs have not been filed in this case. We only have the cert petition and the replies. They haven't even gotten the briefs filed.
It actually got filed about 2 days ago.
2 days ago?
The-
Okay.
the principal
They're not
brief.
up. They're not up on the website yet.
We are supporting invalidation of the Minnesota statute.
All right.
All right,
We're going
National
on to
Pork Producers.
Pork producers, okay.
Pork.
So this is the National Pork Producers Council versus Ross. So in 2018, California passed Proposition 12, which amended the California Health and Safety Act to prohibit the sale of pork from animals confined in a manner inconsistent with California standards. This is an animal cruelty statute. And what it would effectively do, is transform 87% of the pork producers' practices in the rest of the country. That is, Californians eat a lot of pork, and if all the pork sold in California has to be raised under certain conditions, the conditions are, this is going to be an extraterritorial application of California's law throughout the United States. So this is a dormant commerce clause problem. So the question is whether that extraterritorial effect is so burdensome that it violates the Dormant Commerce Clause principles, and that California cannot export its morals legislation, its policing legislation, to the rest of the United States. The District Court for the Southern District of California dismissed the complaint for failure to state a claim, and the Ninth Circuit affirmed. That is, there is no Dormant Commerce Clause problem here. Now, I'm going to argue that that's a ridiculous thing to say, and Gary is going to make the arguments for why the Dormant Commerce Clause is ridiculous. So Proposition 12 has the undisputed effect of changing how pigs are raised all over the country. As I said, it's 87% of pork outside of California is going to be affected. And what this means is that the conditions of the pork is going to get expensive. All the different pork producers are going to have to change the way they house their pigs and ship the animals if they are going to compete in the market for pork. California claims that it is exercising its police powers when it does this, that it's just doing its local health and safety regulations. They make this dubious claim that, I'm arguing here, this dubious claim that there is some rational basis for this law, that actually housing sows in a particular way makes healthier meat. Now, there is no evidence to support that claim. It is an assertion in the complaint without any expert we're on a motion to dismiss here. So it's just an assertion, raw assertion, and the legislative history that supports this law does not have any of those facts either. So this is really the argument is that this is morals legislation, and we know after Lawrence versus Texas that plain morals, just because we don't like it, is not good enough for any kind of law at all. The extraterritorial effect here is extremely burdensome. So a Pike balancing test in the Dormant Commerce Clause asks about whether the burden imposed on the interstate commerce is clearly excessive in relation to the putative local effects. Now, even if we think there is some benefit here, like Californians will feel better about the pork they eat, the extraterritorial effects are substantial, and that is uncontroverted. That is, the price of pork is going to go way up. The change in the pork industry is going to be magnificent, actually. And pork is California will set the national standard for how pork is raised. If that's not a Dormant Commerce Clause problem, I don't know what is.
Absolutely, this is one of the dumbest laws ever to come along. At least until the Massachusetts General Court comes back into session. Then I'm sure we'll top it. Okay,
Fighting
I did not clerk for Justice Scalia twice. I clerked for him once at the D.C. Circuit as a judge, and then clerked for him on his first term at the Supreme Court, 86, 87. And there were 2 Dormant Commerce Clause cases that came up that term. I got to work on both of them. One of them involved the second-generation anti-merger statutes, for those familiar with those, and the court upheld an Illinois, again, really dumb Illinois statute. Justice Scalia wrote a brief concurrence, the last line of which, a law can be both economic folly and constitutional. The Illinois Control Shares statute is at least the latter. There was a second Dormant Commerce Clause case that came up, Tyler Pipe versus Washington Department of Revenue. Has to do with state taxation systems and the extent to which. And at that point, Justice Scalia kind of had it with the Dormant Commerce Clause, because here's the problem. I have a copy of the Constitution. I did bring it with me in my briefcase. There is, in fact, no Dormant Commerce Clause. There is a Commerce Clause that gives Congress affirmative power to regulate commerce among the several states with foreign nations and with the Indian tribes. But there's nothing that says states can't pass really stupid laws. Well, no, they can't impair the obligation of contracts, but nobody is saying that this particular statute does that. Anyway, in the second Dormant Commerce Clause case, it's the only time I was ever, in 2 years, able to get Justice Scalia to do anything he wasn't already planning to do. He was going to write one of these another short concurrences that said, doesn't discriminate against out-of-state commerce. It may be a really dumb idea, but that's Congress's problem. And I said, well, wait, you think the whole Dormant Commerce Clause is garbage, right? He said, well, of course it's garbage. Why don't you just say that? So he actually wrote an opinion where he says the entire Dormant Commerce Clause is garbage. And obviously, if one thinks that the entire Dormant Commerce Clause is garbage, then there's no constitutional thing that California has violated. Here's the one thing I will say in defense of striking down the California statute. There is as a matter of original meaning, if you want to go back to the 18th century like I often do, there is a perfectly good, credible, possibly even correct argument that not only is there a Dormant Commerce Clause, but it's much more powerful than anybody thinks it is, because at least some of the powers granted to Congress are exclusive. And there's a very good case that in the 18th century, the power of Congress over commerce, foreign, interstate, and with the Indian tribes, was understood to be exclusive, meaning, forget pike balancing, states simply could not pass any laws that had anything to do with interstate commerce. In the 18th century, again, that wasn't that big a deal because there wasn't all that much that was interstate commerce. Transplant that into the 21st century when growing pot in your kitchen window is interstate commerce, and you would literally disable all state legislatures. Again, not necessarily the worst thing in the world, but constitutionally kind of an odd doctrine to come up with. All right. Here's the problem. The Supreme Court is not going to say this term, next term, or any time in the near future, there is no Dormant Commerce Clause. And that does leave us with the problem that
I think 3 justices will say that.
I think you can get 2. I don't know that you can get to 3. I think you can get 2 to say that. Anyway, you're not going to get 5. You're not going to get 5. And if that's so, what do you do with existing doctrine that does, since 1970 in the god-awful Pike case, right, tell federal courts they're supposed to look at the state law and they're supposed to think economically and decide whether the state law is too stupid for words? And again, if that's the inquiry, there's a very good case that this one is too stupid for words. But, what? Based on what? So again, if I'm predicting how this case comes out, I'm predicting that they will find some way to invalidate the statute without creating any law that applies to any facts or circumstances beyond this one. But yeah, I would love to see Justice Gorsuch or Justice Thomas launch an all-out broadside and say, of course this law is constitutional. Now, the last thing I will say, and then we'll go to questions. One aspect of the California scheme, I think, it's not the thing that they're focusing on, is pretty clearly unconstitutional. California says it gets to send its inspectors into other states
Oh, right.
to make sure that all the pigs are kept in the right place. And okay. I think it's pretty obvious they can't do that. No more than they could send their inspectors into French vineyards to make sure that the French wine. They can prevent people in California from selling or buying pork, but I don't think they can stick their noses into Ohio's pig pens.
So I think they're going to send this back for pike balancing and bring it and require discovery. So this was dismissed on a motion on a 12B6, and I think there's going to be discovery on exactly what the burden is and how much the burden, which creates all sorts of craziness with the Dormant Commerce Clause. But that's what I think they're going to find a way to adhere to the pike, to require the lower courts to do some balancing under pike.
Okay, let's see if, John, anything from the online group?
Yep. One question. Is it fair to say that the conservative justices of the court would support California's right to ban products?
Okay, super interesting actually thing, what happened during oral argument, and it's a very good oral argument to listen to, is that there is sort of a confusion. Ordinarily we might assign political roles to the justices, but in this case, they're all switching around. So Justice Alito really wants California's law to be upheld because he thinks morals legislation is okay. So he's going to be like, rah, rah, let's strike down the Dormant Commerce Clause, or at least let California have wide leeway. Whereas we had heard Justice Ketanji Brown Jackson and Brett Kavanaugh sort of struggling to adhere to precedent and think about, like, well, morals legislation, I don't know if that's such a good thing. Maybe we should we should get some more evidence about whether raising sows this way is a good thing or not. So it was actually an interesting argument to listen to because the ordinary political identities were not aligned here, except for Gorsuch and Thomas.
Something very important always to keep in mind when you hear the word conservative justice. There are lots of different possible meanings to that. That can mean someone who, according to what academics call the attitudinal model, tends to vote in accordance with a particular political program. It can mean someone who has a particular judicial philosophy about the role of judges. And it can mean what I would call a constitutionalist, someone whose pole star is the original meaning of the document. Those are not the same things. They can lead to quite different results in different cases. Anyone who's familiar with confrontation clause jurisprudence knows what I'm talking about, where these things are on display. And this is maybe going to be one of those circumstances where you're going to see that particular divide coming out to the fore, which to me is all to the good, because I think it confuses more than it helps to lump people together as liberal justices and conservative justices. Maybe a couple of times when that will have explanatory value. Most of the time, it really doesn't.
Yeah.
It's a much more
The
complicated
Dormant Commerce
mix.
Clause creates a lot of chaos on that front.
So, Selena, anything from?
Okay, this question might relate to what you were just talking about. In the post-Dobbs world, the abortion case, can you talk a little bit about what implications a decision in this pork producer's case might have for interstate distribution of pharmaceutical products used to induce abortions?
Yeah.
Yeah, well, that's a good question. Well, it depends on what the state law says.
Right.
So if the state law bans the use of certain pharmaceuticals that's not otherwise regulated by the federal government. So one of the things that's crazy about this pork case, if Congress thinks that this is a problem, 87% of pork,
Right.
Congress can come in and pass a law and say, actually, pork has to be raised in a certain way, some minimum standards, and then California may be violating that federal law, and that's conflict preemption or not. So the real question is there a conflict between a state law and a federal regulation of mephistoprone, for example, or is the state just regulating something by itself that has extraterritorial effects? And so those are just, you can imagine there are different situations that are going to arise in that. But right now, the federal government regulates a lot of drugs and medical devices that take care of reproductive health. And so the state can't just can't pass a law that conflicts with those things necessarily, but they can ban it locally. They can ban it locally.
Okay, let's move on.
All right, I'm 303 Creative versus Elenis. So this is a case about Lori Smith. She's the owner of a graphic design company called 303 Creative, and she wants to expand her business to include wedding websites. She opposes same-sex marriage on religious grounds and wants to exclude same-sex weddings from her business offerings. She also wants to post a message on her website explaining her religious objections to same-sex weddings. So Colorado, she's in Colorado, and Colorado has an anti-discrimination statute that prohibits businesses that are public accommodations, that are otherwise open to the public, from discriminating on the basis of sexual orientation. And that is what Lori Smith proposes to do. At least that's one of the arguments. This is a pre-enforcement challenge, so she has not actually opened for business yet. She's just saying that that is what she's going to do. District Court for the District of Colorado, on motion for summary judgment, because there was no dispute of material facts, granted summary judgment for the state and said that she was violating the civil rights statute. The 10th Circuit affirmed. And the question presented at the Supreme Court is whether applying a public accommodation law like this compels a web designer, or an artist, if you want to call her that, to sell web designing services, or to speak, if you want to call it that, whether it violates the free speech clause. So as I set it up, you can see, is this a services case where you're open for business and your conduct is being regulated, or is this a speech case where what is being she is being compelled to speak through her website, and compelled speech is subject to strict scrutiny. All right, so I am I'm making the argument for Colorado. So Colorado's prohibits discriminatory sales practices, and the question really is what a business chooses to sell to the public remains entirely up to the business. That is, if you're selling books, you're a bookseller. That is not a regulation of speech. That is a we're regulating a place open to the public, and we're going to say you have to serve everyone who comes into your bookstore, you got to serve everyone who comes into your bookstore. That's not a regulation of speech because you sell books. It is not expressive just because the thing you are selling is expressive. We have a very long history in the United States of public accommodation laws that and we define them as regulating conduct or services. This is Heart of Atlanta versus why can't I think of it? McClung, right? And Ollie's Barbecue versus, now I'm not remembering. It's Ollie's.
Was that Katzenbach?
Katzenbach. Okay. So these are Title II cases from the 1960s where racial discrimination was prohibited under Title II, and the question was whether the Commerce Clause reaches that kind of regulation of conduct, and the answer is yes. Now we could say those are anti-associational cases, that it is impinging on the associational freedoms of those restaurant owners and those hotel owners, and therefore it's subject to strict scrutiny because the right of association is in the First Amendment, but we didn't do that in those cases, and we should not do that in this case either. The other reason that this is a loser case is because the speech here, the web's design, the invitation to come to my wedding with my wife, is not the designer's speech, it is my speech. It is my wedding, and this is my website that I have purchased from this designer. This is not the expression of the designer. This is an expression that is made by her for me, and nobody who's seeing that website is going to think she's speaking. They're going to think that I'm speaking and inviting you. That it is what we are doing is compelling a sale here of services, not compelling speech or even artistic speech of the designer. Even if we were compelling speech, subject to strict scrutiny, it would win. That is, equality, this is going to be contentious, you ready? Equality trumps liberty. I just want to say it trumps the First Amendment because it comes later in the Constitution, and you have to read it backwards. The 14th Amendment amended the whole Constitution didn't just add a little part. It amended the whole Constitution, and therefore the color and the tenor of all the rights that came before have to be read through the compelling interest of equal protection. Otherwise, we're relegating gay customers to second-class status, and that is not something that we are allowed to do anymore after Lawrence, Windsor, and Obergefell.
All right, just a few things. Did I mention, by the way, that I have all these libertarian fibers, by the way? They are screaming at me to give a full-throated, full-throttle defense of free speech. The problem is, this case is actually quite nasty doctrinally. Suppose somebody was operating a Build-A-Bear workshop or Fire My Desire, right? People come in and you build your bear and you make your pottery. Would it be open to the person who's running the shop to say, well, no, I have invested so much of my soul in these bear designs and these pottery designs that yes, of course, you're adding the flair and you're putting the nose on, but no, I get to decide who comes into my shop and builds my bear and makes pottery. I don't think that case would make it to the Supreme Court. The question is whether that's this case or whether this case has so much more of an expressive speech element in it that it changes the calculus. Doesn't necessarily decide the case, I'll get to that in a moment, but at least changes the calculus. And as a doctrinal matter, I'm honestly don't know. I've managed to spend my entire professional life avoiding First Amendment doctrine precisely because I've never understood it. So I actually think this is doctrinally an extremely difficult case. Let me just offer the couple of observations to push us in the other direction. This is actually not a First Amendment case. This is a 14th Amendment case. Because, of course, the First Amendment, if you actually read it, says Congress shall make no law respecting freedom of speech, right? And the last time I checked, Colorado, either its legislature or its administrative agencies or any other unit was not, in fact, Congress, right? If there's a limitation on what Colorado can do, it has to come from the very 14th Amendment that Jess was talking about. And it just, I mean, we don't have time to get into this. There's a very good argument that the tradition of free speech circa 1868 was considerably more powerful than it was in 1791. Folks in 1791 did not have a particularly high value on free speech. They had a very narrow conception of what that involves. Fast forward 75 years to 1868, people were a whole lot more interested in free speech, particularly in light of what had happened in the lead up to and then during the Civil War. So I'm not at all sure that the presence of the 14th Amendment doesn't strengthen rather than weaken the case for free speech here. The other thing that I think pushes slightly in that direction is Colorado here has a very broad understanding of what is a public accommodation. The notion of public accommodations is quite old. Even before, long before, a century and a half, 2 centuries before Title II came along in 1964, there were common law doctrines that required public accommodations to take all comers on a non-discriminatory basis. It's just that to be a public accommodation, you basically had to be an innkeeper or a common carrier. Colorado has taken that concept, for which there is a very long tradition of non-discriminatory treatment, and essentially extended it to anything except your kitchen. And maybe it would extend to your kitchen if you invited people in for a brownie party. I mean, no, I'm serious. I mean, that's not out of the question here. So there's a real, we're talking about a very different context in terms of what jurisdictions like Colorado are trying to do compared to the traditions of what was clearly, unambiguously permissible constraints on private commercial behavior that have been around for a very, very long time. But as I said, this is one I don't have a clue how this one's coming out. I really don't. This for me, of all the cases we're talking about today, this one to me is the hardest. I don't.
Especially after Masterpiece Cake Shop, yeah.
All right,
I don't know what's
John, any?
Yes, one question. If the court rules that Lord Smith of 303 creative not decline the design website? Could VO3 Creative still decline to create the website if the website had a message that was offensive to Lori Smith, if based on her religious beliefs?
Say that last part again?
Could, if the court were to determine
Yeah, that
the
she had to-
designer had to develop a website,
Yeah.
but the content of
Yeah.
the website contained a message that was
She was offensive,
to
yeah.
her.
What if the message, someone comes in and says, here's what we want on the cake.
Right.
That Allah is the one
Yeah,
true
right,
God.
right. So these are the hypos that came out in the oral argument. So one of the ways they were trying to figure out whether this is compelled speech and forcing someone to speak a message with which they disagree or not was trying to figure out what is the good that is being sold here. So if this is an off-the-shelf wedding design kit, website kit, and she would make one. The problem Lori Smith has is that she would agree to make an invitation that says, "Come to my wedding. This is what blah blah blah, all this stuff," for a straight couple, and the exact same website, all the same words, everything. She would not make that for a gay couple because the meaning is different because it's for somebody else. And that's the problem with this case, is it's the exact same good to the rest of the world. That's what Colorado's argument is. But to her, it's not the same good because the message has changed because it's for a different kind of person. So the way they got around that in the oral argument was that she could, if she wanted to say, all of my websites say, I believe a marriage is between a man and a woman, that my template will always have that on it, just like it has my signature on it. And if that's my good, and you don't want my good, then fine, go someplace else. But you can't say that the same exact message or the same exact content can't be sold to one person and can be sold to another.
Yeah, that's exactly the problem. It would be a much different case if we were talking about the state mandating particular content
Right.
that be included on every good that you sell.
Yeah.
That's a whole different
that's not what's
body
going on here.
of doctrine. That does not seem to be this case.
They're not forcing her to say anything.
Right. Only other thing I will say on this is the 10th Circuit here actually agreed with all of the characterizations of 303 in this case and said, but even given all of that, there's a compelling government interest here. That one I don't think is going to make it. And by the way, if you read the briefs, Colorado is not defending the reasoning of the 10th Circuit. They are not going into the Supreme Court saying, yep, treat this as a compelled speech case, but find the compelling interest that Judge Zilby wants you to find. No, Colorado knows that's a loser. Just doctrinally, that's a loser. Very, very hard to find a compelling interest in a free speech case.
Okay, Selena?
This is an audience question. Would a bookseller be allowed to exclude books by gay authors? What if the bookseller doesn't announce the policy? Is it better to have discrimination that is announced?
So I think a bookseller can choose whatever things are on their shelf. I think that's the answer. They can't exclude customers from coming to their bookstore. But I think if you only choose, if you're only selling, romance novels, or you're only, I think.
Well, I mean, the lawyerly answer is that's not this case because Colorado has not tried to tell booksellers what they have to sell. It has told booksellers who they have to serve, given what they have. So the Colorado law in question here is only one that's directed to service of customers. If they took that next step and tried to regulate what it is that people sold,
It's a harder one.
that's. I mean, they can regulate who people hire.
Yeah.
If they can regulate the inputs that go into the employment, it's not obvious doctrinally that they can't also, they can probably regulate, which service personnel you bring in.
Right, but that's a different question about whether the state can regulate the bookseller. The question
Right.
is whether the bookseller can choose what goes on the shelf. And if I'm running a restaurant and I'm only serving vegan food, or I'm only serving food that is prepared in what I think is considered moral ways, that's my choice as a business person. But I can't exclude people from my store based on a protected characteristic. Now the question that's harder is it excluding goods from my shelf because of a protected characteristic of that purveyor, a similar kind of thing? I think that's not as much of a public accommodations problem.
Right. We don't have that statute yet anywhere, but that's the sort of thing law professors like to think about. No.
All right, let's get to the
know.
case that is going to destroy the internet.
All right.
Fave.
All right.
Gonzalez versus Google.
So we were saying if we were running out of time, we would choose between Google and Moore versus Harper. We have plenty of time to do both?
Well, we're supposed to be here till 7:30 on these cases.
Okay.
Can we do 10 and 10?
Yeah, we could try.
Okay.
Okay, so Gonzalez versus Google. He's doing the independent state legislator document.
Which is, they're both so interesting.
But they're
right, yes.
super hard. Okay. So Gonzalez versus Google is about Section 230 and the Communication Decency Act. That statute passed in 1996 says that no provider or user of an interactive service, computer service, shall be treated as a publisher or speaker of any information provided by another information content provider. So what that means is that if Google or YouTube or Facebook publish something on their website that is posted by somebody else, they will not be treated like a publisher and subject to publisher liability, which is like defamation or negligence or something like that. And the reason the CDA 230 was passed was to actually encourage those platforms to flourish. And there's a second part of the statute which says that if you block or filter content, we will not say that you are an editor. You're an editorial doing anything editorial that turns you into a publisher. We want to encourage you actually to do some filtering and blocking because the internet's about to become a hot mess. And that was a response to an earlier case, a case called Prodigy, where the platform, which was like the old blackboards, got sued for millions of dollars for defamatory content when it was doing some blocking but not enough blocking. And so the some blocking, the some filtering created publisher liability. They became like an editor of the page, and they were subject to what was edited or what was not edited. The Congress said that's a problem. That's going to create too much liability for all these different platforms. We want to encourage you to block. It's called the Good Samaritan Law. That is any action voluntarily taken in good faith to restrict or availability of material that's obscene or lewd or lascivious. You're not going to be liable for that if you block that stuff. Doesn't turn you into a publisher. Okay, so fast forward and we have the internet. That's 1996. You remember 1996 and the internet? Okay, so fast forward.
Remember Prodigy.
Right. 2022. And what we have now are not just editing and blocking and stuff like that. What we have is algorithmic recommendations. So Google, if you like this, you might like this. That's Amazon. If you search for this, maybe you might like this. And the question presented in this case is whether those kind of algorithmic recommendations, which boost certain content and depress other content, whether that is the kind of blocking and filtering that is within the scope of the statute. And the reason that came before the court is because there was a person who was killed in a terrorist attack in Paris, France. The argument is that it was because of ISIS videos that Google boosted, the YouTube boosted, and that was spreading ISIS messages. And that was a cause, in fact, of this terrorist attack. And Google is in part responsible for that boosting. They are secondarily liable for that boosting, like a publisher. And that's the case before the court. And is this like or not like the blocking or filtering? So I am arguing that it is just the same, that that algorithmic recommendations are within the scope of the statute. And Gary will argue that they are not, and that and it doesn't matter if the sky is falling, although he's probably going to say it's not anyway. All right, so Google. So there's no question that Google is an interactive computer service. Like it fits within or YouTube, Google YouTube, and selective algorithmic results. Can you imagine the absence of the algorithm to determine the result of your search? That is, like, if algorithmic recommendations were exempt from this statute, when you do a Google search, you're just getting a bunch of garbage. Or you do a YouTube search, you're just getting a bunch of garbage. That is, algorithmic search is by definition a form of sorting and filtering and blocking. And if this is exempt from the statute, if this is like a 2.0 form of blocking and filtering, the statute, it defeats the statute. That is, all algorithmic determinations, which is all of platform filtering and sorting, are going to be outside the immunity, and they're all going to be liable for what shows up on that page, on that front page. I think that just defeats the whole purpose of the statute, the meaning of the statute, and we don't interpret statutes in that way. And I guess I would say that if that happens, Google and YouTube and Facebook are going to be sued out of existence. Now, part of me wants to say, like, is that so bad? There is an argument here that the amount of liability that these platforms are going to suffer because of the lawsuits for all the nasty things that come up when you ask for one thing and get another is going to put these companies out of business. And not only the big companies that might actually be able to support it, but the competition on the internet for the other companies, the smaller companies that really need to be able to grow to compete. So the statute is sufficient to cover this cause of action.
All right, between the two of us, there is just a mountain of expertise in technology and IP law. But it's kind of like Hank and Tommy Aaron. She's Hank, I'm Tommy. I know nothing about this stuff, which is one of the reasons why it wouldn't bother me if the internet went away. I got along just fine for most of my life without it. Not sure. But what little I know about this, I learned actually from reading the oral argument in this case and being educated by that noted textualist and originalist, Justice Ketanji Brown Jackson, who I think got this exactly right. Section 230 just doesn't do very much. Just if you look at the statute, it means, yeah, you can't be held liable for what somebody else says. It's just not addressing the algorithmic problem that Jess is talking about. Maybe or maybe not, it would be a really good idea to provide these internet companies with some protection for their algorithmic choices. Could very well be. Just as a matter of ordinary textual analysis, Section 230 simply does not do that. Where the problems come, and Justice Jackson pointed this out as well, is that the underlying causes of action here are really dumb. The problem with the way that this is being framed, the internet companies are relying on a stretch of this statute that has this very narrow compass and doesn't address this. And what they really should be doing is saying, cause of action for this kind of nonsense, right? What we really need is widespread tort reform, not just for internet giants, but to get rid of all these ridiculous causes of action that are out there. And that's, if I were they, that's what I'd be saying is, look, there are any number of ways of coming up with algorithmic recommendation forms where there's just like no plausible cause of action that anybody could possibly bring. You could have a randomizing mechanism. There's like no way anybody could ever hold you liable for a randomizing mechanism. You don't have a randomizing mechanism if you're actually coming up with okay, I thought about this is how I'm going to organize it. It seems pretty clear to me that 230 doesn't address that. Maybe it should, as I said, but it probably doesn't. But anyway, I think the problem is the underlying causes of action.
All right, let's see, we have time for a question.
Yep.
We have 2 minutes left. John, anything?
Yes. Justices Kagan and Barrett both suggested during the argument that they did not understand how the algorithms work, their admission. Based on that alone, should the court leave this issue to Congress?
So right, so this is it's a great question. So this is an example where there was a great moment in the oral argument where Kagan.
Did everybody hear it? All right.
Oh.
Go ahead. You.
Just the question is that both Justice Kagan and Justice Ketanji Brown Jackson said that they don't understand how the algorithms work. And just based on the lack of factual clarity, should they remand to figure that out? And there was a moment during oral argument when there was a lot of uncertainty about what are we talking about recommendations, what are recommendations, how do they work, are there different kinds? When Justice Kagan said, you know, you don't have the 9 most astute internet scholars in the country up here, you know, shouldn't we just leave it to Congress? So that's echoing that question. Now, what I would say about that is Congress wrote, and this is where I'm sort of with Gary on this, or at least the side that he was assigned, Congress wrote a very particular statute that was trying to get people, internet companies, to block and filter, to have a private-public partnership, that Congress couldn't tell you what do you have to block, what don't you block. They said we need to incentivize blocking, and the only way we incentivize filtering and blocking is give you immunity from publishing liability. They wrote that statute in 1996. The internet has changed so much since then, and what we have is a completely different internet than what we had in 1996. Now, there's some debate about how different the algorithms are today than they were. That is the basic structure. But Congress wrote a statute for a different time. And what the court appears to be worried about is they're going to screw up by deciding this, and the internet is going to crash. But I just be the cynical one here and say, like, sometimes they say, too bad, so sad, Congress, you wrote a terrible statute, go back and fix it. Like, it's still unconstitutional now, or there's no, they did that with the Voting Rights Act, the Shelby versus Holder, right? Go back and write it again. If you know, we are the ones that tell you whether this is within the scope of the Constitution or within the scope of the statute. And you can, if we get it wrong, you can rewrite the statute. Here, they're a little worried about doing that. Here, they're a little bit like, actually, maybe we won't rewrite the statute. We'll broadly interpret the statute so that the internet doesn't fall apart. That feels like profound hypocrisy to me, generally, given how they treat statutory construction.
Yeah. So I want to get to the last case, because this is the case that may choose the next president, and we ought to get to it. And this is Moore versus Harper.
Yeah, Moore versus Harper. Every 10 years there's a census, and every time there's a census, states get to, if they want to, sometimes they have to, if they've gained or lost representation in the House, redraw their legislative districts. Well, that's what the North Carolina legislature did after the 2020 census. And to no one's great surprise, what they came up with was objected to on the grounds that it was partisan. Well, the Supreme Court has already said that that's not a federal constitutional claim, so it was challenged in the North Carolina state courts. And the North Carolina Supreme Court, with an elected partisan body, hopefully to no one's surprise, in a partisan 4-3 decision, said that the partisan map of the partisan legislature was partisan, and now you have to go come up with another one. And so North Carolina's district map ended up being drawn up, not by the North Carolina legislature, not even by the North Carolina court, but by special masters who hired statisticians and mathematicians. And that's the map that was used for the 2022 election. Now, the North Carolina legislature comes into federal court and says, wait a minute, let me get my, I'm gonna get my Constitution in front of me so that I can get the, thank you, so I can actually get the exact text here, all right? This is Article 1, Section where is it? I know how to find it in mine.
Oh, sorry.
Okay. House of Representatives. No, that's
Try
not
Google.
Crap.
Article 1. Section.
All right. Anyway, I'll do it from memory.
I'll get it.
All right. The Constitution says that state legislatures set the times, places, and manners of selecting members of Congress. Congress can, if it wants to, override whatever the state legislature do. But the key language in the Constitution is the legislature of the state. The claim of the state legislature here is, look, we're the legislature of the state, and here's the map that we drew. The Constitution doesn't say the state Supreme Court or frankly, even the Constitution of North Carolina gets to determine how the members of Congress, the federal officials, we can just, a state constitution can say whatever it wants about how state officials get picked. The federal constitution has actually specified how it is that you come up with the method for electing the members of Congress, and it commits that not to the state generically, not to the state's constitution, but specifically to the state legislature. We're the state legislature, they're not the state legislature. It is unconstitutional. And it's actually a fascinating claim, because as you parse through the Constitution, it actually makes any number of references to states. Sometimes it talks about the state generically as an entity. Sometimes it talks about the legislature of the state. A couple of occasions it talks about the executive authority of the state. Sometimes it talks about the state courts. Here's the bottom line question, and this is a law professor's dream. When the Constitution talks about those state bodies, is it talking about them as institutions or as functions? What do we mean by that? Well, you can talk about the legislature as a particular institution, a concrete set of people doing certain things in a certain way. You could also talk about it as that institution, that body, whatever it happens to be, whatever form it takes, however complicated or simple, that results in laws. And the thing about the federal Constitution is it creates a very elaborate system for the federal government about how those various powers get allocated. It says almost nothing about how states internally can structure themselves. The only constraint is that they have to be a Republican form of government. But beyond that, if a state wants to have a parliamentary system, it can have a parliamentary system. State wants to have its Supreme Court be its ultimate lawmaker. There's nothing in the federal Constitution that says it can't. So the real question is, when we see those words, the legislature of the state, are we attaching them to a body, the North Carolina representative bodies, or are we attaching it to this overall system of making laws, which could include contributions from a governor who may or may not have a veto power, contributions from the state Supreme Court, which may or may not, under state law, have power to review and possibly even rewrite what state legislatures do, and certainly the Constitution of the state. Under the North Carolina legislature's theory, because the federal Constitution has directly allocated that authority, even a state constitution can't override it, because of course state constitutions have to give way to federal constitutional commands. And the Constitution is not consistent about this, right? Article 1, Section 2, Clause 1 also has a reference to the legislature of the state, and is obviously in that context referring to the state legislature as an institution, because it says that the way you figure out who votes for Congress is you look and see in each state who votes for the most numerous branch of the state legislature. That's obviously not describing a function, it's obviously describing a body. Those mentions of the executive authority I've talked about for filling vacancies in the House and originally in the Senate as well, and for making demands for extradition, obviously that's a reference to a function, not to a body, because there's nothing in the universe that says the state has to have a governor as its executive authority. If a state wants to have the Speaker of its House as its chief executive authority, there's nothing in the federal Constitution that says it can't do that. It could have a council, it could have the Chief Justice of its Supreme Court, right? So that's obviously a reference to a function. So now we've got the question in, it's 141. There we go, Article 141. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. Is that a reference to an institution, in which case the state legislature wins this case? Or is it a reference to a function, in which case they lose, right? It's that simple and it's that complicated. And I originally started out thinking, well, of course it has to be describing a function. I actually still think that's the best answer, but the more I stare at the provision that comes right before it, right, that talks about how you figure out who votes for Congress, and it's obviously referring to the state legislature as a body, as an institution, I start to get queasy. That's where I am.
So at oral argument, there was a lot of figuring out, like, where does the state legislature come from? The state legislature in North Carolina comes from its constitution. The constitution creates the legislature. And so one of the questions presented, you could reformulate the question presented in this case, is can the state legislature, the body, regulate under the elections clause inconsistent with its own constitution?
That's right.
And the answer to that really has to be no, because the Constitution creates the legislature. And the Constitution is interpreted according to its own Constitution, North Carolina's Constitution, by the state Supreme Court. And so if the state Supreme Court has interpreted the Constitution to say that elections, free and fair elections, have to be a certain way and partisan gerrymandering is not free and fair, then when the legislature makes partisan gerrymandering, they are violating the Constitution per the state Supreme Court. And so all of this is, if the legislature is a function of the Constitution, the state Constitution, who figures out what the Constitution means? Well, under ordinary theories of judicial review, and the Supreme Court has not deviated from this, it is the highest court in the state. It is the state court. And so the Supreme Court should care that North Carolina has interpreted its Supreme Court, its Constitution, to say that this is it's state unconstitutional gerrymandering, because the legislature is a creature of the constitutional structure. The idea that the court will tell North Carolina what its constitution means, even though there, arguably is, obviously the supremacy clause and all that, should make many justices on the Supreme Court very uncomfortable, given the structure of federalism that we have and the structure of federalism that the Constitution they say has set up to give states as much autonomy over their own elections as possible. That is, if it's just a federal court coming in saying, no, your Constitution means something else, the legislature isn't beholden to the Constitution and to the court, that sounds like a lot of overreach by this federal bench.
And I'm going to close us out with the weakest rebuttal ever, because I actually think that that's right. with one asterisk. No, the reason I think that's right. Think about this. Okay, suppose you're the North Carolina legislature and you say, okay, the Constitution commits this to my determination, regardless of what my state constitution says, regardless of what my state Supreme Court says. What is the process by which the North Carolina legislature actually chooses the district? I mean, presumably it makes a law. Well, what is the process by which it makes a law? That process presumably is dictated by the North Carolina Constitution. And just so imagine, this isn't the case, but suppose the North Carolina Constitution says the way the legislature makes a law is you got to have a 3/4 majority in each house. Okay? Would that be binding, or in this particular instance, when they're picking maps, could they do it by majority vote? Because the Constitution is silent about how the legislature operates, and you would think majority vote would be like the default value in the absence of anything. So the brief of the legislature here tries to draw a distinction between those sort of procedural ways in which legislatures act, like if they can only do it with the governor's signature, that's okay. They could, and substantive requirements like the free and fair elections.
That was a loser.
Yeah, I don't see that standing up. The only asterisk I will give to that is I think the North Carolina Supreme Court bungled the interpretation of its own state constitution. Yeah. For 150 years, that has not been a federal constitutional claim. Since the Murdoch decision right after the Civil War, the Supreme Court has said federal courts are bound to accept the determinations of state Supreme Courts on state law. That's never made any sense to me, by the way. But I think there's zero chance the Supreme Court's going to revisit that question.
All right, one question? If not, if we don't have one, that's okay.
You have one from
John?
not present?
The National Conference of Chief Justices filed an amicus brief
Yes, they did.
in
Of course they did.
opposition
Yes, they did.
to the independent state legislator doctrine. Are the state chief justices opposing the doctrine on a bipartisan basis?
I don't know if you're aware of that.
Yeah.
I mean, I knew they filed the brief. I haven't looked to see what the composition of that is.
I believe in oral argument they said it was.
It
but-
would not shock me if it was.
Yeah.
Judges are judges.
And-
All right, so I'm going to test you on this one a little bit. Supreme Court watchers and Supreme Court clerk, the Supreme Court's at the lowest level of confidence, probably in history at the moment. Probably the leak, is a lot to do with that. Should there be a code of ethics, a code of ethics for what about the code of ethics that apply to federal judges?
I think so. I don't know why they should
Professor
be
Lawson?
exempt.
I'd have to see what the code of ethics looks like. No, I'm being quite serious.
I'll show it to you. It's called
Yeah.
the Codes of Conduct for
Yeah.
Federal Judges.
Yeah.
You
It's a
probably
bit
have
much.
seen it. So
Yeah,
He doesn't believe in rules.
I think it goes way too far. I am not a big fan of taking. I shouldn't say this, Judge, of taking judges and putting them on too much of a pedestal. I'm not sure it's certainly not accurate, and I'm not sure that it's healthy. Just for the same reason that I think the notion of lawyers as a profession somehow different from being a plumber is not a healthy or accurate one. So should there be a code of ethics for plumbers? Well, I mean, you do the right thing. The code of ethics is you do good and you don't do bad.
There probably
but
is
the
one.
idea of imposing one because this is a function that somehow has this status, I'm uncomfortable with that
The point
kind
is
of
that
thing.
the Supreme Court of the United States is the only judicial body that
Right,
is
it's a
not
little
subject
so-
to
right.
the Code of Ethics.
Right, but I would go the other way. I would lessen it
Right.
for
Let's
everybody
raise it for
else
everybody.
rather than raise it.
There you
right.
go.
very-
We can have a good debate on that.
Right.
all right,
All right.
we'll come back for that one. The one last case, but you're not going to
No.
comment on it. I'm
Oh,
not going
you're
to
gonna-
ask you to.
oh.
This wonderful, interesting case.
What is this? Oh, the
So-
right.
Yeah, the bankruptcy code. Yes.
This is the other case from the First Circuit, which is a case involving whether Indian tribes are subject to the U.S. bankruptcy code. This is a case that I wrote and was reversed 2-1 by the First Circuit, and I happen to agree with the one. But they took cert on this case, and it's also going to be a very interesting case. But they just granted cert. We didn't include it. It probably doesn't merit one of the big cases of the year unless you happen to live at Mohegan Sun.
Yeah.
Then it matters a great deal. So join me, please, in thanking the professors for. By the way, what you just heard would have cost you $60,000 this year, so it was quite a bargain for you. So thanks very much.
All right. Good job.
Yeah.